Peace and love, peace and blessings to all those that are listening today. You are listening to the Empress Shea Marie Harris Bay, and I am recording this because I would like to continue sharing my journey, my research, and my journey on the search to find truth and freedom, true freedom, to really get, go down the rabbit hole to figure out, what the corrupt government and the powers that be have done to get us all in the situations that we're currently in today, where we're facing so much turmoil. So many things are happening, with these, pandemics, or I like to call them plandemics, because they were definitely all planned. And, you know, this is a book, or it's a 7-page document that I would like to currently read right now to you all, those that are listening. I hope to spark the interest of more people. Also, I've always been on a campaign since earlier this year to raise more awareness, help to raise the consciousness of the people, but on a campaign to encourage more people to read. They said if you want to hide something from a black person, I'm not black. I'm an indigenous brown person. My skin is brown. I'm not a black crayon or color of a crayon. I'm a copper color American national. And they said if you want to hide something from these people, put it in a book. And it couldn't be further from the truth. The scams, the schemes, the plots, and the conspiracies that these people have done for over hundreds of years to keep us in bondage, to keep us in slavery. And so what I would like to do is share some of what has been hidden from mostly all of the American people. And this is not just for the American people, but this is for all governments around the world. This is what has been actually taking place. So I hope this enlightens you and sparks an interest in you to go and do more research, do due diligence to help free yourself and help free your family and the people around you. So I'm going to start by reading. It's called Learn to Express the Trust. And to begin, it says, the problem has been the lack of knowledge on the effects of trust on our lives. We have become master, not slave. Not to be construed as legal advice. Learn to express the trust. Technology views everything as a trust first, and not as a construed debtor, etc. Learn to express the trust and to follow the rules. We've been learning about creating, claiming, and moving titles, which is what this report is based on. We're utilizing A4V or AFV, UCC, IRS, GSA forms in expressing the trust. Now, before I continue on, I am building a community, and the things that we're learning, some of the things that are discussed in this document are not what we are all utilizing, but I found this to be a great document to learn about the trust and give people an understanding of more of what is taking place. So I highly recommend, not taking everything you see here for face value, as far as if there's processes or remedies that are shared. But what I do recommend is that you just pay attention to what is being said here. So they say, how they got us, legal fiction. The assumption that something is true, even though it may be untrue, made especially in judicial reasoning to alter how a rule operates, specifically a device by which a legal rule or institution, which is a trust, is diverted from its original purpose to accomplish indirectly some other objective. The constructive Sestake SSS straw man trust is an example of a legal fiction. And if you've watched any of my previous videos, you know I put a video out about the straw man, Meet Your Straw Man, reading that book. So I highly recommend you go back and watch that if you have not. In 1901, Henry S. Maine wrote, "I employ a legal fiction to signify any assumption which conceals, or effects to conceal, the fact that the rule of law has undergone alteration, its letter remaining unchanged, its operations being modified." It is not difficult to understand why fictions in all their forms are congenial to the infancy of society. They satisfy the desire for improvement, which is not quite wanting at the same time that they did not offend the superstitious disrelish for change, which is always present. Privity of contracts, where privity means the relationship between two parties, each having a legal recognized interest in the same subject matter, such as a court case or a piece of property. The relationship between two parties allowing them to sue each other, but preventing a third party from doing so. The requirement of privity has been relaxed under normal laws, modern laws, and doctrines of implied warranties or trust, and strict liability, which allows a third-party beneficiary or other foreseeable user, both trust terms, to sue the seller of a defective product. Could that non-performing product be a straw man or a slave? Too many students of the common law privity of contract became a fetish, i.e., you're supposed to agree or have knowledge of the contract to be liable student practitioners. As such, this change has operated to deprive many a claimant of a remedy in cases where, according to the Moors, i.e., the dead with no vision of the time, the claim was just. Many came to believe that a court action could not be assigned. Even now, it is asserted that a man cannot be made the debtor of another against his will, but the common law has been influenced by equity through trust where no common law disclosure be given, and the trust is wrapped in a colorable common law contract. By the law merchant, i.e., the Uniform Commercial Code, a debtor could become bound by a UCC-3 through silence to pay a perfect stranger, even if he had no privity of knowledge. The common law courts made use of fictions, trust, and pretended they were not doing that which they were doing. Bingo. This is what they don't want you to know. Hansen Principles of Law and Contracts. Privity of estate. An estate is a trust, a mutual and successive relationship to the same right in property as between grantor and grantee or landlord and tenant, also termed privity of title, aka warranty deed, a trust, which is you, as grantee, trustee, filed by the previous owner, as grantor in a successive trust. Expressing the trust with our signature and an A4V in 1933, they took the gold from backing of Federal Reserve notes. A contract could no longer be completed. No consideration or value could be given. Common law vanished in the public, so all contracts become colorable lies. So trusts fill the void. Colorable contracts wrap a trust at the core, so everything is trust, and the gifting of the res into the trust, forming the corpus of the trust. Your signature is the representation of the trust in all your past, present, and future labor or assets, where your signature is the res or value or principle. Trust. If two parties have the four elements of a trust and employed one of the other four methods of formation of the trust, then they have a trust, recognized in law, whether they know it or not, and the trustee can be held liable. Black's Law, two kinds of trust is express and implied. Trust, the right enforceable solely in equity or in court to the beneficial enjoyment of property to which another person holds legal title. A property interest held by one person, which is the grantee or trustee, at the request of the grantor or settlor, for the benefit of a third party, the beneficiary. Express trust. A trust created with the settlor's express intent, expressing the trust voluntarily, usually declared in writing, an ordinary trust as opposed to a resulting trust or a constructive trust. Implied trust, which is involuntary, also called constructive trust, the Social Security account, the form through which the conscience of equity, which is the court, finds expression against one who has obtained property by wrongdoing. When property has been acquired in such circumstances that the holder of legal title, which is the one who possesses 90%, may not in good conscience retain the beneficial interest or title, which is the other tenth, equity converts him into a trustee. They deem us to be holding legal title illegally, and they convert us into the trustee. It is sometimes said that when there are sufficient grounds for imposing a constructive trust, the court construes a trust. It implies a trust because we did not express a trust first. The expression constructive trust is absurd because constructive is derived from construe, not construct. The court construes the circumstances. It explains them. It does not construct them. Blacks. We don't express the trust, so they construe it to their benefit. Sestake trust is an implied or constructive trust. Social Security number trust account. It is a beneficiary of the foreign situs trust because you didn't express the trust after age 18. The sestake is the remedy by which the court of equity finds justice for the one who has lost his property to one who does not legally have a right to the property. You are being construed as the one holding the property illegally. One is holding the property illegally when it has been acquired in such circumstances that the holder of the legal title may not in good conscience hold the beneficial or legal title, and equity converts him into a trustee. They construe the trust with you as the trustee under debtor-creditor law. You were supposed to pay, you didn't, so you are in breach of fiduciary duty. You can go to jail. You should express the trust with your intent under, say, equity or 1776 law form, which is pre-United States and pre-statutes and codes. So you could then pay with private credit or negotiable debt instruments, NDIs, and you would be safe in making private payments with private credit. They put you under public policy where you have to pay with Federal Reserve notes. The substantive rights of the real man lie with equity, but the court construe you as trustee with duty to pay them as construed beneficiary in Federal Reserve notes. If you have a drinking glass in the private, a title is used to represent that drinking glass in the public. Express trust is usually expressed in writing. Implied trust. An implied trust is created when you don't express it. An equitable remedy imposed by the court. the form through which the conscience of the equity finds expression against one who has obtained property by wrongdoing, or when the holder of the legal title cannot in good conscience retain the beneficial interest. Equity converts him into a trustee. To understand trust, study the workings of the IRS tax code, the motor vehicle code, municipal courts, property taxes, etc., that which we have been induced into signing. I recommend The Law of Trust and Trustees by Bogart and Bogart, and Scott's on Trust, also Wills and Trust in a nutshell. So these are books that you can get online. So you will want to look those up. Wills and Trusts. Okay. Okay, keeps pulling up the same thing, so I'll keep reading. It says, key points in trust law. He who claims trust must prove trust. That burden of proof is a prima facie case, the proof of which is in the expression of the trust. 4 elements to a trust is 1. Parties, grantor, trustee, beneficiary. 2. A specific res, property, or the thing. 3. You must have the intent or an intent. And 4 is the purpose. Trustee holds the trust property and is subject to equitable duties for the benefit of the beneficiary. They make us trustee beneficiary by the mere acceptance of benefits. Beneficiary declaimer can waive. No one can be forced to be a fiduciary trustee, only voluntarily. Did you understand that you were creating the trust when you signed that document? Is this your signature? One is presumed to know the nature and content of what he signs, but no parties to the trust, the grantor, trustee, or beneficiary, need to know or understand that they are forming a trust. That does not negate the trust. Section 23, Restatement of the Law on Trust, and also out of the Gilbert's Law Summaries on Trust, UCC is key. Incomplete instruments means signed writing, whether or not issued by the signer, the contents of which show at the time of signing that is incomplete, but that the signer intended to be completed by the addition of words or numbers. They add pay to the order of $1 million. They turn the offer you signed into a check. You can do the same, i.e., turn it into a check. Instead of trading our labor for Federal Reserve notes, we have to learn to trade our credit for them. Trusts are formed by 1. Transfer of the res to trustee, who is neither settlor nor beneficiary if the transferor expresses simultaneously with or prior to the creation of the trust. Transfer is another portal termed under UCC sub 200's negotiation. A transfer is by one of 4 methods: endorsement, delivery in bearer form, assignment on a UCC 3, and also by operation of law. But a transfer is also a trust term. A transfer using one of these methods forms a trust. 2. A declaration in writing by owner of the property that the owner holds the property as trustee for the owner and another person as the beneficiary. 3. Appointment or assignment. If the beneficiary makes a prima facie case, the burden of contradicting it or showing a defense will then shift to the trustee. Bogart discusses how there is a certain ill-defined threshold the beneficiary must prove. Then the burden shifts to the trustee to prove that he met his responsibilities. He has no evidence he can prove unless he made the payment. Why would a beneficiary make a claim if he got paid? And 4. By contract. The one who is able to prove the expression of the trust elements and has the burden of proof to do so. If not, there is no trust. In commerce, the trustee is presumed to be guilty. The one who is eligible to prove the expression of the trust, U.S. versus SNEP, wherein the U.S. CIA sued SNEP because he had 2 non-disclosure agreements with the CIA to not publicize data. They sued him under trust law, not contract law. If there is an absence of a fiduciary, a court may appoint one. Equity will not allow a trust to fail for lack of a trustee. Acceptance of benefits is presumed under Bogart 169. 191. Acceptance is presumed. Acceptance of benefits is presumed under Bogart 169. Number reference following are also from Bogart 191. 191. Acceptance is presumed. There is nothing you need to do formally to become the beneficiary of these scams. The beneficiary may disclaim under 170 to 72 and 170 to 205, where conduct by beneficiary, including silence, amounts to a disclaimer, a refusal to accept the gift of the equitable property right. Since acceptance is normal, a claim of renunciation must be supported by clear evidence. Disclaimer is nunc pro tunc, now and for then, to the start of the agreement. 172 at 227 through 228. Conduct by the beneficiary, which is inconsistent with his benefit, may amount to an implied disclaimer, and statutes which require surrender of such trust will be in writing do not apply. Since a surrender is based on giving up equitable interest, this is the unknown beneficiary problem, which can be your defense because the illegal trustee has no obligation to pay. How do you make a prima facie case? Simple. Come in with all the documents copied and make an allegation. Beneficiary must show he is a beneficiary managed by a fiduciary of a trust with a trust res. In other words, express the trust. Where the beneficiary is unknown, the trustee has no obligation to pay. When they construe you to be the trustee who hasn't paid, what would your defense be? The unknown beneficiary? Since the trust was not expressed, how would you know who the beneficiary was? Or you could re-express the trust to your liking with yourself as beneficiary. Identify the parties that need to be paid. 161 at 131 and 134. Breach of fiduciary duty can put one in jail. Misapplication of fiduciary property or property of financial institutions, embezzlement, misappropriation. 18 U.S.C. 371. Defraud includes embezzlement. 18 U.S.C. subsection 371. Conspiracy to defraud the United States. The general conspiracy statute creates an offense if 2 or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner for any purpose. The trustee may deviate from the terms of the trust if all beneficiaries agree to that. Scott's on Abridgment. So Scott's on Abridgment is also a book. Abridgment of the Laws of Trust by Austin Wakeman Scott. So this is another book that you can Google. As an example, let's say there are several beneficiaries and the trustee wanted to make a donation to an organization which is not listed as a beneficiary in the trust. If all but one of the beneficiaries support it, the trustee cannot. It must be unanimous. Polk, who was the beneficiary, versus Farmers Trust and Loan, 157 U.S. 429, 1895. To reconvey the mortgage, you must terminate the trust. When you signed the application for the loan, the bank monetized your signature, got paid, deposited into an account. Then you signed the promissory note at the closing, which they deposited onto the right asset side of the ledger, and deposited your security agreement on the left debit side. Do debt validation, then get them in dishonor, which we use for revoke of power of attorney. Re-express the trust with appointment of trustee equals bank. Since they're the beneficiary, the trust terminates because they can't be both. Now the trustee must disperse funds to the beneficiary. As grantor, you instruct the trustee they're in breach. Debtor-creditor law is where you're paying for 30 years. Establish holder in due course status. Follow US UCC procedure. Do an A for V. C. Agree with your adversary quickly. So we're going to go read that. It says Matthews 5:25. Agree with thine adversary quickly while thou art in the way with him, lest at any time the adversary deliver thee to the judge, and the judge deliver thee to the officer, and thou be cast into prison. Providing information on how the Sestate Trust was formed and the trust has gone dead, and they are construing the trust and operating the trust without you. With this material provided here, you can straighten this out as beneficial owner with ultimate controlling interest. So this document is called Rules of Signature, and it's by Kenneth Michael, and it is copyrighted. Okay, so it says, how was the beneficiary trust created? Your signature authorized it and granted the existence of the trust account. The SS5 application was for the Social Security number account. The signature that you signed with, was it qualified or unqualified? Most likely unqualified at that time. So the trust was formed and you didn't say anything as the beneficiary, and the trust has gone dead basically, and you didn't say anything as the beneficiary, and the trust has gone dead basically, and they are construing sorry, I read that twice. They are construing the trust and operating the trust without you. You need to go back in and straighten all this mess up by making another reapplication and give the qualified signature on the application. Yes, as long as I have the 4 elements and 1 method of formation, I can prove that it has been done. SS5 application. That is proof you are the grantor because you signed and you brought that number into existence. The trust account per your authorized signature as grantor. Then sign the beneficiary card as beneficiary and signature, and make copies of that and send them copies of what you did, your signature, and now you've notified them according to due process. Recommend private sector autograph. Always right hand justified in blue ink, thumbprint in red. Private sector autograph. So your autograph will be as shown. All rights reserved by the authorized representative, which will be your first and second name, with the first name, then dash, then your second name, then colons with your last name, and you want to put your thumbprint there, and you want to say under duress without recourse. This reserves your right. Now you have the proof of the original that you are the grantor and the beneficiary on that Social Security strawman trust account. What we're leading to is, for example, in a mortgage, we started out with a promissory note, which is really a title. They want your signature to gain access to your exemption account, which is the Social Security account, the Sestate Trust, public liability, which is drawn against the foreign situs trust, the birth certificate trust, or private assets. Accounts must balance. So the promissory note is just a decoy so they can grab your signature and add words and numbers to it. The key is, how did you give your signature? It is the rules of signature and the rules of forms that counts. You never want to give your unqualified signature in the public because it is going to be construed as the straw man. That gives them accommodation, signature rights, carte blanche, and access to your account. You can restrict your signature so that you have access to the account. You want to sign before signature by grantor, by trustee, or by beneficiary, the three parties of a trust, or sign as authorized representative, AR. I call the AR the portal term because it portals into your UCC under UCC 3-402. Now, I want to stop here because the processes that we're currently learning, if you're in my community, then you know what I'm speaking of. If not, I highly recommend you go to freedomwriters.org and take a look at what we're doing, how we're accumulating assets, but also in our Telegram chat, we are learning the particular process into signing as the beneficiary and being able to pay our bills, get our debts paid, as well as acquire things such as vehicles and cars and things of the such. So you want to definitely come to our Telegram chat that you can access through freedomwriters.org. And Freedom Writers is spelled with a Z, and I'll also have the link in the description area of this video if you're watching on YouTube, so that you can access us. You just type in your name, email address, and phone number, and you'll be able to get access to the Telegram chat. Telegram is where it's at, you guys. It's definitely a lot of great connections, a lot of amazing things happening over in the Telegram chat, separate from the regular social media such as Facebook and Instagram and things like that. So definitely want to be on Telegram. But I'll go ahead and continue reading this document. Like I said, some things we don't take for face value, but just for the sake of reading and getting an understanding of what this person may be particularly saying, I'm going to go ahead and finish reading. So it says, under UCC 3-402, where the authorized representative is signing for the contract debtor-creditor relationship, it does also apply to trust with a Form 56 appointment to the authorized representative, who may function as a co-trustee. See, this is what we're not doing any of this. So, you guys can read the rest of this. It's just been up here long enough. Okay, about the authorized representative. So it says the Social Security account trust is really a sub-trust, and by giving qualified signatures, that tells them you know who you are. If you don't express the trust, they will construe the trust under creditor-debtor law. By not expressing the trust, we drop the ball. They pick it up and construe it in their favor, with you liable for payment with Federal Reserve notes as a 14th Amendment citizen, which I am not a 14th Amendment citizen. Liable for statutes and codes. If you express the trust, you can make payment with your private credit. As you function, you're going to have to give a key restriction to correspond with the duty you're performing. That is good to be looked at and compared with what you're trying to accomplish in a comparison to how you're signing. Unless the key fits in the door, the key won't open the door. Rules of signatures defined. Okay? So that was definitely a great read. So, rules of signatures defined says you must punctuate your name in order for your given name to be fact, not an adjective, pronoun, fiction. Here's why. With permission by Anna Teresa Balazs, BA English, MS Education. A name is considered a proper noun, a noun being a person, place, or thing. Note the word person and not living being. Interesting, as person is a corporate identity or ID entity, correct? An entity originally meant being, existence, ID being the unconscious force from which the force of our psyche originates. However, when you look up identity on the internet, it only goes back to the Latin idem, meaning sameness. I would need a complete Oxford dictionary to get the story all the way back to the original guttural utterance, as this word is older than Latin, as most root words and words that deal with states of being are. And I think this explanation of origin, as I found so far, is incomplete. Sameness is what? Probably like the living thing. When we speak colloquially and other ways about our identity, we have a concept of it being who we are. And when we lose our identity, we lose our concept of who we are. This definition seems to be hardwired in our brains. I don't think anyone has a problem understanding what it means to lose their identity or understanding the feeling that they cannot express their identity. I cannot concur with what I found on the internet, which does not break down the word into a prefix or root, or offer an analysis of the word as a compound noun. Entity is a word in itself, so I would venture that ID is a word in itself and used in psychology, and we have a compound noun in the word identity with the hyphen that would have been needed lost over time. That being said, a name, while being a proper noun, while being part of our identity, is also an appellation or something attached as a descriptor to identify a particular person, and hence has the force of an adjective. That's where the idea of adjective pronoun probably comes in, with a pronoun defined as something that takes the place of a noun or person, place, or thing. Suspicious, but interesting. When we trademark our name, it becomes a thing that has to have permission to be used. In other words, it becomes a fact, as it's a thing. Trademarking your name is part of what we are supposed to do to protect ourselves. Punctuation has the effect of setting apart. So by punctuating your name, you are setting it apart from other things and other thoughts. A thing is a fact. A thought is a thing, and therefore a fact, as opposed to a descriptor or adjective describing a thing as separate and different from some other thing. Therefore, I would concur with the statement, punctuate your name, i.e., Jones is the family name, John-Henry, because it makes you a fact, not an adjective pronoun or fiction. And so I conclude my preliminary analysis. Anna Teresa Balash, BA English, MS Education. U.S. Government Printing Office Style Manual, Chapter 3, Capitalization Rules from the U.S. Government Public Office. Trade names and trademarks 3.25. Trade names, variety names, and names of market grades and brands are capitalized. Some trade names have come into usage as generic terms. Cellophane, thermos, and aspirin. When reference is being made to the formal company or specific product name, capitalization should be used. Proper names such as your name should only be spelled with the first letter capitalized only. Corporations are spelled with capital letters. Your name in all capital letters. The straw man is a corporation set up for you by the United States corporation. Another truth is that your federal government is a corporation. Your all capital letter name represents the corporate way you are identified by the government. The government is considered a corporation and they cannot deal with the real person, us, body, flesh, and blood. So they needed to conduit or let's just say a straw man. They needed a conduit, or let's just say a straw man, so it can connect us to the fictional governments we know and love today. So this conduit or liaison is our legal name, straw man, and it is written in all caps. See suggested autograph block. So we're going to go there to the suggested autograph block. Okay, so that was this. This is the suggested autograph block. Okay. All right, we're going to go back to the original document. I'm going to go here, but I believe this is the 45-page document, 56-page document. So I'm actually going to read that on another video, but let's check out the nature of the rights of the Sestate K Trust. So this too is 23 pages long. So to separate and not make this video so long, what I am going to do is come back. I'll read nature of rights of the Sestate K Trust in another video, and then I'll read the new technology, accept for value, return for value in another video. I thank you all for listening. I hope this information sparks interest in you and sparks a light in you to get up and want to learn more and do more about freeing yourselves from this bondage that we're in, having to pay for debts when everything is already paid. They're double dipping and causing us to stress over just having to survive, and we don't have to, you guys, because everything is already prepaid. With that being said, if you want to join our community, we look forward to having you. Go to freedomwriters.org. That's Freedom Writers with a Z, or just click on the link in the description area of this video to go to our Telegram chat. With that being said, you guys, I appreciate your time. Please give me a thumbs up on this video. If you'd like to comment, please do so. Give me your feedback. I love to hear from the listeners and the viewers of my videos. I love your feedback. With that being said, look forward to connecting with you all soon. See you on my next video. It's your girl, Empress Shay Marie Harris Bay. Peace and love, Islam.